Hello. Good morning, good afternoon, good evening. From wherever and whatever part of the world or day you are coming from. How are you? It's been wonderful. It's been wonderful. Great day. Can't complain. Well, welcome to Rush to Judgment with Jessica. I'm Jessica. And here I want to share with you that I am not an expert, nor do I specialize in any particular area of educational information. I am just here to add my opinions and critical or biased judgment on any topic, various topics or subjects that I might find entertaining or interesting. So yeah, that's what we are here to do. We are currently working on finishing up the George Zimmerman trial. Now, we have gone through the majority of it so far. And we are on day 11. We finished up all of the testimony of day 11. So if you missed that, you can go back to the previous videos. They say part 1 and part 2. Those are the testimonies of the people that were here for the day. This video is going to cover some hearing, some bickering, some arguing between the lawyers. So we will probably play this a little faster. Closed captioning is not available, but we'll play this a little faster than normal. We'll start it at 125. See how that works. It's going to be the little goofy dude doing it for the state, so he talks a little fast. All the people in the state talk really fast. I don't know. But we are going to, both of these videos are really, the first one is really rather long, but we'll skip around because I don't think it's all relevant. And a lot of it is a lot of legal stuff that I honestly don't understand nor find entertaining. But if you do, then I'm sure you can find the actual video somewhere else. Here, we're not going to do that because I don't want to. So, sorry. Sorry, not sorry. But yeah. Okay. So, we're going to go do this. We're going to go do this. And voila. Do this. And let go.
Please be seated.
Sit down.
We're back on the record, and I see Mr. Shoemaker sitting on the stand, and Mr.
This is the guy for the animation. They did the proffer the other day to get him in.
Going through your
and
CV,
now they're doing a hearing.
my understanding is that you received a Bachelor of Fine Arts degree in graphic design in 1985, am I right?
Yes.
And as far as additional degrees or anything like that, that is the end of it, am I right?
There's always ongoing education, and I've been educated beyond college.
I understand, but nothing in terms of graduate or postgraduate work that resulted in a degree?
No.
Okay. And
That's
nothing,
rude.
sort of, you're not being held out as anything like
You don't have to have a degree
or
to be
physicist or anything like that, am I
smart.
right?
Correct.
Okay. Graphic design, essentially you take computer software and, for lack of a more specific way to put it, you draw things or create things.
Can you do it?
That's one version.
Okay. What's another?
There's a lot of different types of design, information design. There's a lot of different things that you can do with those tools.
All right. As far as your prior experience in testifying, I think you said 20 criminal actual cases where you were appeared in court.
Declaration or testified.
Yeah, I want to know specifically where you testified in a court in a criminal trial in front of a jury. How many?
17.
17. How many of those was your testimony ever even really objected to or challenged at any kind of pretrial hearing or anything?
You mean challenged, or what do you mean?
How many times did whatever side you were testifying for, and I understand it's always been for the defense, but how many times did the other side challenge or object to you being permitted to testify?
Whenever I was qualified as an expert.
So there was always some kind of pretrial hearing?
Whenever I testified in court, there's always been a pretrial hearing.
Okay. So 17 times. And how many of those involved animations created with the motion capture suits?
Probably about a dozen.
A dozen? Can you tell me the last one? Give me the title of it.
It's not your business.
It was Green, I believe it's People versus Green
Okay.
in Placer or Auburn County, I believe. Yeah, it was in Placer City,
Now
or
I know-
Placerville, sorry.
Placerville?
Yes.
I know that you have also testified that you often create these animations based upon such things as surveillance footage, like you showed us the one with in the parking lot and that sort of thing. How many of these involved a situation like this one where you had no film or anything like that and you were basically inserting figures?
He uses probably,
It's
I'd
very rare
say.
that I have film to be able to match the animation to the film.
Okay.
So
Why would they need them if they had film?
that was pretty much the only one where I've done the matching onto a security camera.
How many of these then did you involve figures that are actually in what I'll call just term a melee or a fight between the two of them? How many times have you done that in court in front of a jury?
Twice.
Twice?
That includes this one.
That includes this.
Most of them they're not person-on-person fights. Most of them are shootings. It's mostly just shootings.
As I understand it, most of what you did in these other cases are the animations that you create are you take bullet trajectories that you can, physically measure and implant those or embed those into your animations and illustrate them. I think there's a few I've read about where you use a red line or something like that to show how it goes, right?
Essentially, yes.
Okay, so you're taking the raw data, just like you use total station data here, and you're drawing lines or putting figures in places where they could have been, but not like this case where you're describing a physical ongoing fluid situation between two people.
There's some that I've worked on where it's multiple gunshots. So you've got movement from the first one to the next one to the next one. So it's a sequence of events.
Okay, but not interaction between the two physically. You're talking about measuring trajectories again and things like that.
Correct.
Okay. So what is that last one, or the only time that you've actually testified in court in a scenario similar to this one? Tell me when and where that was.
The last one using the suit, or
Using the suit, involving more than just, involving a physical fight between two or more people where you've had to recapture a fluid situation in court in front of a jury.
that was the Greenberg.
Greenberg. Okay. And tell me a little bit about that one.
That one was an ex-police officer came up to a vehicle and shot the person that was in the vehicle. So I had to determine the position of each of them and their positioning when he was shot, their movements.
Okay. So that involved, again, some distance between the two of them in a shooting, one inside a car and one outside a car or something like that.
Close approximation to each other, yes.
Okay. But one sitting in a car, and I think you said one shooting into the car from outside. Is that?
He was within the open door of the
Okay.
truck.
Okay, not as in this case where you're trying to describe a ongoing scrum between two or more people.
Correct.
Okay, so this would be the
I have
first
one
time.
that I'm currently working on now not this one. There's one I'm working on now that is the same as that.
I know about working on. I want to just focus right now for the moment on things where your testimony has been accepted for court purposes in front of a jury in a criminal case. And it sounds to me, if I'm not mistaken, like this would be the first time this particular scenario has arisen where you've been called upon to do that in court in front of a jury.
The suit that I've used has been accepted in court in 2 other cases.
I'm not just talking
That I
about the
worked
suit.
on.
I'm talking about all the variables that we've just mentioned, where you're using the suit, inserting figures that are physically interacting with one another in a rolling fight in court in a criminal case in front of a jury. This would be the first one, right?
With this
You're
close
such a
contact.
dick.
Yes.
Okay. And I think you said, at least according to your CV, you're actually the only company in the country using the wireless motion capture suits for reconstruction purposes.
Correct.
So there's no issue about whether your peers or fellows in the industry are doing the same thing for this kind of thing. You're the only guy who does this that has those,
Just
right?
say it's junk
Correct.
science.
There's a
and
limited
we know.
number of, the company that makes the suit differentiates it from all the other suits that are available.
And while I think I understood you say that you are you know how to use the software. You don't know anything about the inner workings or the algorithms. You're not a code writer or software engineer or anything
They
like
don't
that,
want it
right?
in because they don't want to see
So
that the
if the
situation is actually
program were not
plausible.
working properly, unless it shut down completely or started giving you crazy results, you wouldn't necessarily know that, would you?
Why don't you
I
give
can
them
verify
a
whether it's
situation
operating
where you think
correctly
it
or
is
not.
plausible
It's
and
been
let him put
calibrated
it
at
into his
factory,
little
and also
suit?
every single time that I use it,
Why
I
don't you do
calibrate
that?
it myself.
Let me go to the suits in particular.
Oh,
In
'cause you
this case,
probably
what you did
can't.
is you got the raw data, I think you said, from the total station, and then you went out to the scene and you did your mapping thing, and then you put 2 people in suits, right?
Correct.
You did your little mapping thing.
And
So condescending.
out there at the scene, basically you told them what to do,
Dick.
right?
According to, yes,
Who were these people? Were they male or female?
2 males.
How big were they?
They were relative size to Mr. Martin and Mr. Zimmerman.
How tall were they and how much did they weigh?
The one who represented Mr. Zimmerman was, I believe he was about 5'8".
Okay.
The person that was representing Mr. Zimmerman was,
So Mr. Martin?
or Mr. Martin, sorry,
Okay.
was approximately 5'11",
Approximately?
5'11" or 6 foot.
Do,
It's not really that important for the person that's wearing the suit to be the exact size of the person that you're doing the movements for.
all I want to know is, do you even know exactly how big they were? Did you measure these people?
He was 5'11".
How do you know that?
I'm 6 foot. He was virtually the same size as
So
I
you did
was.
an eyeball estimate based on him standing there near you?
That's all that was necessary.
How much did they weigh?
That wasn't relevant for the reconstruction of it.
Is that do you know or not? I mean, I'm just asking.
They were similar
Just a-
stature to the people that I was representing with the motion capture suit, to Mr. Zimmerman and Mr. Martin.
How long were their arms and legs?
Average size.
Does that mean you did not measure?
I didn't measure their arms.
And they got into poses, as I understand it, what the suits do is they give off pulses of energy, whether it's light or whatever it is, that are documented by these cameras that you set up. Is that how they basically work?
No, that's not the way mine.
Tell me how they work.
Mine has 16 accelerometers, and just like your iPhone, when you move it, it will register the movement. So with these 16 accelerometers, they send a wireless signal to my laptop, which has antennas that accept the signal. Then they take that and they apply it to a figure represented on the laptop.
They meaning what does? You said they take the signal. What takes the signal?
The antennas that come in go into the software, and it's applied to the character
And
that's
the
in the
pulses
computer.
given off by the accelerometers, are they,
The pulses from the accelerometers, it goes into, there's 2 transmitters that fit on the back of the suit, and those send the signal to the,
You're asking
laptop.
these
so
questions,
does
but
each
he doesn't
accelerometer have its
even
own
like
sort of unique
act like
code
he
or
gives
pulse?
a shit.
yes,
Okay. And when you're rapidly moving around, are you telling me that you can differentiate or that the antenna differentiate among each
Asking
of
the
them?
questions, but he's not listening to the
And
answers.
you also
because
have
he
a green
already
light
has the
to make sure
argument
whether it's functioning properly or not.
that he doesn't want this
Whether
in.
what is?
And he
Whether
doesn't
each of
give a
those
shit about what
accelerometers
the
are
answers
functioning
are.
and sending a signal properly.
He's just gonna say, Your Honor, this is junk.
The version
it
of this
doesn't
animation
need to
that
come
we
in.
played for the court this morning, is that the final version now?
Yes,
Okay. How many prior final versions of this have there been? In other words, how many have you tendered and then had to change again?
there was 2 prior versions, and they were adjusted for more accuracy
Okay.
according to the witnesses.
Well, and that's sort of where I want to get to is you actually never, you adjusted based on witnesses. You haven't actually ever read or listened to the actual testimony from the witnesses, have you?
There's police reports that,
Courtroom testimony, not police reports.
not the courtroom testimony, no.
In fact, what you did is you changed them based upon what Mr. Zimmerman's attorneys told you people said in court.
Yes.
Okay. And that actually apparently was different enough from the way you'd originally created the animation that you have changed it at least twice.
Just to be more accurate, yes.
Do I understand that most of what you do is when you say reconstruct a crime scene, you take known points, things that are mapped and known and static in their position, shell casings, trees, sidewalks, that sort of thing. And that is reconstructing a crime scene. When you start adding figures and animation to it, what are you doing?
That's also creating the crime scene. What I do is I take coroner's reports, all the discovery, specifics about the scene, total station data, if it's available, my gathering of data, and I put it into context. Sometimes when a jury receives, let's say, a coroner's report, for example, and they talk about the angle of a bullet trajectory, the jury doesn't, they get that angle, but they don't really know how that applies to the scene or how is that relevant and what position they would be in the scene. So what I do is I take all the different aspects of the case and put it into context.
All right. Exactly which pieces of evidence, let me rephrase that. Exactly which testimony did you incorporate into this animation?
There was Jeremy Weinberg's.
Did Jeremy Weinberg testify in court, to your knowledge?
Are you talking about testimony or are you
Yes,
talking
sir.
about police reports or
Specifically
discovery?
testimony. I understand you had available to you a bunch of stuff. I want to know what actual evidence, courtroom
Stop
testimony was incorporated
being
into this
a
animation.
dick.
Um,
There is a way
It was
you can do things
Jennifer Lauer's
without
testimony,
being an asshole.
John
This
Good's
man right
testimony,
here is not being an
and
asshole. Mr. Prosecutor
Moore.
man, you
Other
don't
than
have to be an asshole.
You show in this animation
This
an
computer
initial
man is just
contact
doing
between
his
two figures,
job.
represented, I assume, to be Trayvon Martin and George Zimmerman, right?
correct.
And whose testimony did you use to describe that initial, to depict that initial encounter?
Part of it is off of the, from the discovery that you gave us was
I'm sorry, maybe I wasn't clear. Whose testimony did you use?
testimony.
Yes, sir.
Maybe you could clarify, is he talking about trial testimony or just pre-trial testimony?
Well, I think that it has to be consistent with testimony or evidence presented at trial.
Certainly,
That's
and
what
of
the
course,
case law
all of,
says.
But
and all of
assuming,
Mrs. Zimmerman's statements are in trial, so if the
Well-
witness is aware of that.
Well, the witness could testify what he used, and that's what the
I
question
think he was
is.
confused by trial testimony.
Okay, well, I'll go ahead. Please let me finish. It has to be trial testimony
they're
or
all
evidence. So
bitchy.
the question to you is, what trial testimony and or evidence did you use to incorporate into your animation?
For the initial contact, it was Jennifer Lauer's statement.
according to what you understand her statement to be, you believe that she saw that occur?
She didn't see it occur, she heard it occur.
Okay.
That was the point.
You are, however, depicting it visually, right?
Correct.
Okay. She certainly didn't testify that she could depict it visually, right?
She just pinpointed the initial contact point where it started,
She pinpointed it
at the T intersection to the left of where she was in the condo.
somewhere to the left of her condo is where she first heard things, correct?
Correct.
Did she ever say that it must have started there? Not mine. Mine's here.
It was on vibrating. It's not vibrating anymore, but it's not yours. Okay, go
No,
ahead.
Your Honor. Oh, I'm sorry. Your indication is that she, according to you, somehow testified that she knows that it must have started there?
I have a question.
If you want a clarification, you can ask Mr. Manti where you want
Okay.
to clarify.
So for evidence, which the judge was asking, does that include police reports?
No, sir. I want you to assume that anytime I'm asking you about actual evidence or testimony, I mean something that has gone on in this courtroom during trial, okay?
Okay.
What someone said outside of court, For right now, I want you to assume that that is not evidence, okay?
Your Honor, that's what I was trying to clear up earlier. It may not be as to Ms. Lauer, but the witnesses got to identify, you got to understand what's in trial. And if
Okay,
you
I
get-
will explain that to him, but I don't want you,
Try
by
not
your
to- try not to
objection,
push it.
by your objection, trying to infer to this witness how he should answer.
Exactly.
So, it would be anything heard by the jury in this courtroom, either heard or seen, by way of testimony or evidence introduced. That's what he means
Well,
by
I'm
a
not
trial.
sure what that is because I was not allowed to watch the trial, so. Okay.
So then if I were to ask you, does this animation accurately show what has been testified to in this trial, is your answer you don't know?
I'm not sure what the proceedings, what went on in court.
Okay,
So according to the evidence that I've received and from your office,
well, I'm not talking about the discovery matters and all the stuff that you used initially for the first set of animations or the underlying stuff, and I'm not talking about what a lawyer may have told you. If I were to ask you, does this animation
It's the same
accurately
thing
show
that
what has been
anything
testified
anybody else
to
has done.
in evidence in this courtroom, is your answer you don't know? And
The
again,
two doctors
my answer to that would
previously.
be yes.
your answer is
If it's not in my consultations with the attorneys, it would have changed. So it's been adjusted to testimony in court.
none of which you have heard or observed yourself,
Correct.
Right.
and none of which evidence you have actually seen yourself.
None of the evidence which has been in court, yes.
Okay. So, part of this animation shows this initial encounter where these two figures kind of walk up to each other. And I understand you believe that the victim in this case, Trayvon Martin, was left-handed. Am I right? You said that.
I believe so, yes.
And you don't show anybody jumping out of a bush, for example.
There was no evidence for that.
Nothing. Okay. And you don't show anybody just sort of emerging out of the darkness or running out of the darkness. It's just these two people kind of walk up to each other and stand face to face for a while, right?
For seconds, yes.
Okay. The animation also, you do show and plot the location of various items, cell phones, flashlights, sprinkler boxes, right?
Correct.
And sprinkler heads,
Yes.
Right. a couple trees,
Yes.
all right? And that's sort of in almost a 40-foot swath along that sloped ground that you described, right?
Correct.
However, the animation I saw kind of just takes a big white arrow from the point of that initial walk-up encounter and zooms to a place 40 feet away where essentially we then start to show the two figures bound up together,
Tussling.
right?
Correct.
And the reason for that is,
Having a
Is
where did they
because
get teleported or what?
that just shows the direction of Mr. Martin and Mr. Zimmerman, consistent with witness testimony or witness reports, police reports, and with the trail of evidence going down that direction.
The trail of evidence, you'd agree with me, is just a trail. It by itself doesn't have a direction, right? In other words, whether it's going left to right or right to left as you're looking at it, the place where things are found doesn't independently have a direction until you start bringing in what other people have said about how it happened, right?
Correct.
Okay.
The reason for the arrow is moving from the one witnessed event down to the next witnessed event.
Okay.
I didn't add anything in between there in terms of movements of the figures.
Because the animation cannot show it because you have no idea how it actually happened, right?
Correct.
Okay. Now, when we get to where the figures again reemerge, you have a figure that you show to be, I guess, represented to be witness John Good, right?
Correct.
How tall is John Good?
6 foot.
And you know this how?
I was given that information from the attorneys.
Okay, so again, not from anything that came out in court, but from the attorneys?
Yes, we got it from Mr. Good.
Okay. And
Wow.
where was he standing?
There's a sliding glass door and the right side slides over. He was on the right side of the sliding glass door, the right door, about a foot out from the door.
About a foot? And where do you get that from?
Mr. Good,
From Mr. Good's in-court testimony?
from consultation with the attorneys.
Okay. And as far as where on the patio he's standing, did you just pick a spot where you put the figure?
It's just straight out from the door, 1 foot.
So you don't know whether he stood to the left of the door, to the right of the door, straight out from the door, wherever. You just picked a spot.
I didn't pick it. That's where said he was standing,
Where he said he was standing when he was here in court?
through consultation with the attorney.
Okay. Was that before court?
I'm not sure when.
You have no idea.
It was during trial, but I'm not sure when.
Okay. And he told you exactly where on the patio Mr. Good was standing?
Yes.
That patio is how big by how big?
I don't have the exact measurements. I believe there's 2 pillars on the corner, and I believe it's about 7.5 feet from one pillar to the other pillar.
Did he tell you he was standing within 1 foot of this pillar or 1 foot of this pillar?
He
Or
told me
anything
he
like
was
that?
standing 1 foot straight out from the one door, which is where I placed him.
1 foot.
Yes.
Let me start with something else about the animation. It is true, is it not, that, and I should rephrase it, I'm not really starting. It is true, is it not, that the animation actually contains artificial light? In other
Correct.
words, okay, so it purports to show things even though you know it was dark outside.
Correct.
And my understanding is that you made intentionally no effort whatsoever to accurately document the lighting conditions and everything else.
Because the most important thing with the video is
Is that a yes or
seeing
no?
detail. Yes.
So the most important thing on the video is seeing detail, even though you know that that wouldn't have been the detail that night.
Correct. There's plenty of other people can testify to the lighting conditions.
Okay, so if I were to ask you if the lighting conditions portrayed on that animation are an accurate representation of what they were that night, you would say no.
You're correct.
Okay.
I would say no.
And in your decision about where to place the people, now your decision about where to instruct the people who were wearing the suits to go and what positions to assume, that was all done months before any in-court testimony, right?
Not months. It was probably within the month before.
Okay, within a month before, but certainly prior to any trial proceedings.
Correct.
Okay. And you told them based on your best estimates as to what materials you'd been provided by the defense attorney.
Based on the police reports and the interviews, yes.
Right. And how many interviews did you actually read?
There was Jennifer Lowers and John Goods. There's a couple, there's 3 handwritten reports.
Handwritten, like witness statements, you mean?
Yes.
Okay. And that's it?
Yes.
Okay. So based on those, you told these people wearing the suits where to go and what to do.
Based on that, plus based on the 911 call,
Okay.
and timed it with the 911
Well,
call.
let me get into that. The 911 call is actually placed by Jenna Lauer, correct?
Correct.
Jenna Lauer saw none of this, correct?
Correct.
Yet you build into, and John Good, from whose perspective a lot of this is shown, was not on the phone with 911 at the time, right?
Correct.
Nonetheless, you take Jenna Lauer's 911 call and show figures doing certain actions at certain points in that 911 call, right?
Correct.
Now, I understand why you might be able to pinpoint the gunshot in the 911 call, right?
Right.
But as far as any of the rest of it, do you have any idea where those figures were actually at any point in the audio of the 911 call and what they were doing?
But the only figure other than Mr. Zimmerman and Mr. Martin is Mr. Good.
I'm talking about Mr. Zimmerman and Mr.
I
Martin.
think it was in the middle of explaining the answer. I request to be allowed to.
Were you finished with your answer?
No.
Okay, you may finish your answer.
Who
Yeah. So shut the fuck up.
specified when he came in during the phone call, during the 911 call. On the video, he specified when he came in, how long he was out there, and when he went back in.
I'm sorry, on what video did Mr. Good say that he came in during a specific point of Jenna Lauer's 911 call?
That was through consultation with the attorneys, his modification, adjustments of the video and its placement.
I'm sorry, are you telling this court that you were told that John Good stated exactly where he was during portions of Jenna Lauer's 911 call?
How long he was outside.
Not how long he was outside. I want to know, you have matched specific audio from that phone call to specific actions, both by John Good and the 2 figures on the ground, right?
Correct.
And what I want to know is what in-court testimony or evidence you were actually provided that tells you John Good saw 2 figures doing X at the time Jenna Lauer was saying Y.
There's not any in-court testimony on it.
There's not any out-of-court testimony about it either, is there?
There's consultation with the attorneys on how long he was out there, when he went back in, and when he came out.
Okay, and this is, so again, you're integrating the visual perspective of one witness who's not, has no idea what Jenna Lauer, right? John Good has no idea what Jenna Lauer might be doing because they're not even in the same house, right?
It's not just based on Jenna Lauer's call, which he couldn't hear at the time, but he can base it on when the gunshot went off.
Well, I understand when the gunshot went off, but what you're telling this court is prior to the gunshot going off, or even afterwards, but certainly prior to the gunshot going off, that John Good, visual witness, and Jenna Lauer, audio witness, neither of whom know anything about what the other's doing at the time, that you can somehow match up exactly what John Good is seeing at the exact moment Jenna Lauer is saying something?
If you take the 911 call where the gunshot went off, and if Mr. Good said that he was in the condo a particular time before the gunshot, you have a point when he went into the condo. He has a particular time of how long he was out there. So if you backtrack
can
from the
infer.
from the gunshot, you can determine from those when he came out and when he went back in.
Those times, of course, are absolutely not exact. Those were all complete estimations, correct? Right? I mean, John Good never said, I got a stopwatch and I can tell you 30 seconds before the gunshot I went inside. Nothing like that, right?
It's an estimation on his part.
In
correct?
fact, okay. And therefore, it is also just nothing more than an estimation on your part. I mean, you can only put
It's
in.
based on a witness that was
But
there.
can't you
that said
take
how
the
long he was
time
out there
Okay.
from the
and how long it
gunshot?
was
Here's what I
You
want
know
before
what time the
went off.
gunshot
I wanna
was
focus
because
on.
you have it on
So it
the
is-
phone call.
That animation is very specific. You play a portion of that audio recording in conjunction with supposed actual video or simulated video from John Good's perspective, all based on nothing more than estimations.
By the person that was witnessing it.
And therefore, by you as well, because you can only put in what you've got to work with, right?
Correct.
Okay. So none of that could be said to be exact or accurate to the point that you can say for certain that that's what he was seeing at the time Jenna Lauer was saying a certain word. Right?
I don't think it has to be specific to the exact word that she was saying.
Well, your animation though makes it very specific, doesn't it?
Yes.
There's nothing in that animation that tells me the call is generally going on now, and I'm not sure exactly what part this is. That animation shows exactly and sounds exactly that these things are going on at the same time, right?
Correct. This is a scenario according to
Because you
witness
have
and
the
evidence.
911
I'm sorry.
call,
Which
which you
witness
have
and which
the
evidence
time
that came
frame
out in
for.
court? Or are we back to estimations based on
Hear
what
the
attorneys told you?
yelling. You know
Consultation
what's
with attorneys.
happening.
Okay.
You
On
have the
his
gunshot.
movements.
Would you
You
agree
have
with me
no
that
more
there's no way
yelling.
John Good could ever
You have
say
that time frame.
at the time
Do
Jenna
you
Lauer
not?
was saying this?
Am I
was doing
missing
this?
something? Like, I don't even fucking understand what we're arguing about. Like, you have that
I don't
time
think that's
frame.
what he based his
I'm not
time
asking.
for being out there.
I'm not
Yeah.
asking what you
He
think.
can't say exactly according to what she was saying.
And in fact, he
Oh
was
my
gone
God, what are you
from any
even
visual
arguing
view.
about?
while Jenna Lauer is still on the phone and for a period of time before that gunshot ever happens.
Seconds.
Okay.
It's
But no
not
one
fair.
knows, no one has talked exactly how many seconds that might be because nobody had a stopwatch on it, right?
Shut
Correct.
up
Okay.
about your fucking
Nonetheless, that
stopwatch.
animation
Are we
purports to
done?
show it, right?
Yes,
So is the animation,
to record it in that location because you can interact with like the slope of the grass and other elements. But once that's on the scene and the scene is created in the computer, then you can take that, drop it into the scene and adjust it so that it's most accurate.
so when you were at the scene, you hadn't already, for example, measured exactly where the shell casing was and like put a dot, or had you?
We laid out little markers.
You did lay
where
out
they were.
Okay. Now, do I understand then, the second part of the second series of questions, you then just took the figures and put them in exact locations vis-a-vis things like the shell casing and the porch. In other words, say, for example, 6 feet from the porch and 3 feet from the shell casing. You put the figures in a specific place, right?
Correct.
And you did that based on what evidence and testimony as to the exact location of the figures?
Are you talking about the ones straight out from Mr. Good's condominium? All the still figures from that? Those
Well-
were placed there based on Mr. Good's testimony and in consultation with the attorneys.
Let me talk about position 3, for example. My understanding is that you placed the figures where they were in the third position based upon your belief as to your knowledge of the location where the shell casing was found and your belief as to the ejection of the shell casing from that firearm that's not in the video, right?
Correct.
Okay.
That's one. And relative to the position where Mr. Zimmerman was found,
You mean Mr. Moore?
or Mr. Martin, sorry.
Okay, but that's position 4, right?
Correct.
All right.
But
Position
3 is
four.
relative to 4.
Okay, I'm going to stick to 3 for the moment, all right? You said that you put the figures in a certain position relative to the shell casing. Now, to my knowledge, no one testified about being this close to the shell casing. So is this an estimation on your part based upon you thinking that the gun must have defected to the right and the shell casing must have gone X distance?
Correct. It's just in proximity to the shell casing, so that the shell casing is on the right of Mr. Zimmerman.
On the right, but in other words, 2 feet to the right, 3 feet to the right, 4 feet to the right, you really have no idea exactly how far that would be.
It can't be that far away from where Mr. Martin ended up. So the proximity of evidence marker number 6 has to be pretty close proximity to the third position.
I understand generalized proximity. What I'm getting at is, would you agree with me that how high the gun is up off the ground might affect how far that shell casing goes and therefore where it lands?
There's a lot of variables that could have,
A lot of variables. So
Not- innumerable variables, but
none of those variables for which you had actual direct evidence, right?
just that a shell casing ejects from the right on a 9 millimeter.
You just found it. We know where it was found, but we have no idea where it came from. We know where it landed, not where it took off.
We know approximately where it came from.
I'm asking, your animation shows these figures in a very specific spot. What I'm just asking you is that an estimation based upon your estimation about how the shell casing got there?
It's based on their last position and based on their previous position and based on their last position and based also on the shell casing, location of the shell casing.
The last position, fourth position,
Correct.
is what happened after the defendant claims that he shot Trayvon Martin, that Trayvon Martin fell off him, that he then jumped on Trayvon Martin's back and moved a portion of his body, all right?
Correct.
And we have absolutely no idea exactly how far that happened. We just know where the body ended up being found, right?
It's in close proximity to the final
I
position.
understand it's all in proximity. This whole thing happened within a 40 square foot
You're
area.
not really giving me specifics. Are you talking 5 feet from where I have them? Are you talking 3 inches from where they are? Or
What I'm asking you is, why does your animation give me those specifics?
because it's to the one side of the shell casing, it's to the other side is the cell phone position. Plus their previous position is just up the slope from their third position.
The animation itself is based on a series of estimations.
Can I interrupt you for just 1 minute? I saw that animation one brief moment from a computer. And although I remember generally the things that you're talking about, but specifically positions and stuff, it would be helpful to me if we had the animation up and you had him explain the positions that you're talking about, because
Do you have your laptop still there with you, sir?
have we figured out a way to
I
put it
think
up?
we can get one of these several computers that has an animation on it to work now.
Okay,
So if
can
take
we
about
please
2
do
minutes.
that? Because I'm really trying to follow the testimony, and without looking specifically at each figure or position you're talking about, 3 and 4, it would be helpful to the court if I had that in conjunction with the testimony.
Sure.
So can we try to do that?
Yeah.
Absolutely. You're going to
Can we please?
let's try something else. PC friendly, right? That's our best chance, I think. I'm sorry? Your laptop?
Can we
is
get the
working?
screen down?
Okay, let's get a projector warmed up and your laptop cranked up. Why don't you question it from your table? Well,
God, why are you such a dick? Like the judge asked for it, and you want to be like, he's like such a baby. You poor thing. This is a poor thing. Just think I'm talking to you. Because I'm saying it in that voice. You think I'm talking to you.
yeah, we do. I'm not sure you can stop it, right?
Yeah, I can stop it. I don't believe I have position 3.
There's mine.
Okay.
Okay, so
You wanna go ahead? So now we have an illustration sort of third position, right?
Yes,
And I know the things in the yellow circles are items of evidence, physical things. One of them is the final resting place of Trayvon Martin's body. One is the shell casing, right?
correct.
Okay. And the place that you have these vis-a-vis those items in the yellow circles is an estimation.
The
Right.
placement of the yellow circles?
No,
is
sir,
an
the
estimate?
placement of the figures with respect to the yellow circles.
Correct. They're positioned in between the items of
They're
evidence.
just generally speaking in between them, but as far as telling me that they should be in exactly that location as opposed to a few degrees to the left, a few inches or a few feet to one direction or the other, you couldn't really tell me, because that's, of course, not what you're trying to do with the video, right?
Correct. They're positioning relative to each other is the purpose of the video.
Well, and you also, speaking of that, even their position relative to each other, you couldn't tell me exactly what angle the person's head who's on top there should be, right?
Correct, because it wasn't still. So
Right. The whole thing is actually moving. So again, this is in sort of an estimation.
what part of it are you talking about as an estimation?
The actual positions of the figures. And I'm talking not,
It's not an estimation. It's a placement according to Dr. DeMaio.
Dr. DeMaio told you they looked exactly like that?
Their positioning, yes.
I'm sorry, he described that exact degree of tilt and everything to you?
Within 2 inches.
How many inches did he say Trayvon Martin's head was off the ground?
That wasn't relevant.
Okay, so the answer is, again, this would be an approximation. Because you don't know the exact answer to that question.
Approximation of his head?
Yeah.
Yes.
Okay.
Whoa. That's one.
As far as these white things that are depicted here, these are the sort of the sprinkler boxes, the hard plastic boxes that are out there.
Sprinkler boxes and drain boxes.
Okay, those hard metal or plastic covers, whatever they're made of.
Correct.
Okay. Now, you also, do I understand it, reviewed at least one of the statements of the defendant, in this case, George Zimmerman.
That was supplied to me. I'm not sure which one you're talking about.
Did you use any of those to create this animation?
Any of the animation or what part of the animation you're talking
Any
about?
part of it?
The initial, some of the initial portion at the T intersection.
And that is it?
Yes, all the rest are based on the other witnesses.
Okay, so all the rest of it is based on something other than what the defendant's statement was. And which statement of the defendant are you talking about?
The video walkthrough.
Okay, that is the only one you used?
Yes,
Is there some reason you didn't use any of the others?
because I had other witnesses that placed the test or that in the police reports positioned them throughout the animation.
Let me be more clear. You only used it as it relates to the beginning of this video where you see the two figures walk up to each other and then one of them punches the other, right?
Correct.
Okay.
And I used it in conjunction with Jenna Lauer's testimony about that is where the initial conflict took place.
Is there a reason that you only used the video walkthrough statement as opposed to any of the other several statements? Or did you just pick that one because it was the longest or whatever? I mean, I'm just asking.
Oh my God.
I had other witnesses that laid out the scene from then on.
Okay. Talk to me about, and if we can, I'm done asking questions about this, Sean. So, thank you.
Are you?
I'm not even going to start with that.
You just quoted it.
Okay.
I don't believe you are.
Talk to me about any types of validation that have been done with this particular method that you use to create animation.
Any other validations on
Right, on either the several types of software or programs that you have used, those, other than just buying them and assuming they're working right, and that they're not at least failing to work for you, are you aware of any sort of validation studies that have been done on any of them?
validation studies on the motion capture suit?
Only on the suit?
Motion capture suit and also the 3D software that I use. It's used by engineers, and with all the time that I've spent using it, if there was some inaccuracy in any of the measurements or in using the software, I haven't found any.
Let's talk about how accurate it is. Are these things accurate to what measurement? In other words, are we talking hundreds of an inch, thousands of an inch? What are these measurements designed to be specifically accurate to?
as accurate as you want, thousands of an inch.
What did you set them to here?
Just what was relevant to what I needed in terms of positioning of the items, measuring, for example, from the porch to the shell casing. And
Okay.
there wasn't anything in this that required thousands of an inch of accuracy.
And I think I perhaps asked it and didn't follow up earlier when I asked about when you're directing people who are wearing these suits and they're engaging in whatever behavior that you're having them engage in. Are you telling them to sort of go at it with a simulated fight, or are you telling them to simply, pose this way, stop, move, go this way, that sort of thing?
Just move according to what the witnesses wrote in their police reports in terms of what position they were in, what they were doing, for example, ground pounding or that type of movement, and just to how they would naturally interact with the ground and the slope and the sidewalk.
So you were sort of almost like directing a movie, saying to an actor or an actress, go here and do this. They weren't just doing it on their own?
Correct. It was based on the location of evidence on the scene, the type of surface they were on, what was written in the police report in terms of what they were doing at that location.
When we're talking, for example, about the actual motion, for example, at the first part of that tape, where there are figures in motion, did you have them attempt to simulate the actual speed of that? Or did you just simply have a person in a capture seat make that motion and then you adjusted the speed using the software?
The swing and the reaction to the swing is, it wasn't sped up. That's a natural movement.
So that's as fast as the actual actors happen to do it.
Correct.
Any idea whether that's accurate as opposed to simply another estimation?
It was just a movement portraying that occurrence
So as to whether it's,
and how somebody doing that motion, recording somebody doing that motion.
if I were to ask you, can you tell this court for certain that it is an accurate depiction of the motion and the blow that it's supposed to depict? You'd have to tell me no, right?
It's an accurate movement of somebody swinging and striking another person in the face
Just as the actor decided to do it.
as a human would move. There's other ways of doing that reconstructionists do animation, which is hand animating on the computer, where you take a 3D figure, move an arm, advance it some frames, move the arm again. And so they're just estimating about the way something really moves. With the advantage with the motion capture suit,
On your animation, would you then go back and fit that into the facts that you utilized as the foundation for your animation?
yes,
And have you done that in the generation 3, or the most recent generation of video that you created or animation, based upon consultation with me and saying such things as, did you in fact modify the animation as we discussed matters?
yes, the whole purpose of it is to get it as accurate as possible.
And did I then discuss with you certain testimonies in trial that led to modifications?
Yes,
For example, on some of the stills that you had gone through with the judge, was there changes in those stills based upon actual trial testimony as opposed to deposition or statement testimony? Estimate from there the time it might take to connect. Would that help calibrate the animation even more refined?
yes.
Okay. And would that be able to be accomplished tonight, for example? If I gave you the timing of the call?
I wouldn't be able to render and redo the animation, but I can do some marking when he came in.
Not to just discourse with you as you're on the stand, but if there was a few second difference, it would require simply moving the audio tracker of the Lauer call, would it not? The animation would stay the same?
Yes,
Because that's the only relation, would it not be? If the gunshot is relating the timing of Lauer's call, that would only change the audio track a few seconds one way or the other, would it not?
I believe it would affect Mr. Good's time that he went into the apartment or into the condo.
Well, let's go forward on that, presuming that your estimation of your use of his estimation as to how many seconds from leaving the view of the scene to hearing the gunshot is close to accurate. And we'll,
Well, go ahead, because I don't want to interject what my notes say, but we'll do that in argument when you're doing your argument.
well, I don't want to miss an opportunity to clear up an inquiry. If we can, it's the three of us right now.
Is there any objection from the state?
Objection as to the court asking questions?
Yes.
None whatsoever.
Okay. My notes, and of course the record will correct me if I'm wrong, the only times that Mr. Good gave was that he was at home. It was between 7:05 and 7:15 p.m. when he was watching TV in his living room with his wife, and he heard the noise outside. The other times that he gives on cross was the entire time he was watching was 8 to 10 seconds. He doesn't say where within that time frame he saw the 8 to 10 seconds, but we do know from his testimony that he was dialing 911 and waiting for it to connect when he heard the gunshot. So I don't know how long he was in the house before that gunshot, and he's dialing 911, and I don't know what the 8 to 10 seconds were, if he says it was either 7:05 or 7:15. So the problem that I'm having to relate to that right now is the use of the Lauer 911 call in conjunction with Mr. Good's testimony. I don't understand where that timeline is coming from based upon John Good's testimony.
My understanding of his testimony, and again, the record, I'll need to review the actual transcript, was that he left the area of the view of the scene, turned around, and immediately grabbed his phone and started
Went
dialing.
upstairs.
What time did he go out there? At 7:05 or 7:15
He
or
went out there,
thereafter? Because I'll read you my notes, and of course, the record is what
Yes,
is
Your Honor.
correct. These are just my notes. But he said from it was between 7:05 and 7:15. They were watching TV in the living room. He heard a noise outside. First, it was a faint noise, and he didn't think anything of it. He couldn't hear words. Then he heard the same noise, just louder, seemed like it was getting closer. He couldn't hear any words, and he didn't know if there was more than one person. He went to look out of his glass sliding door, which had the blinds drawn. He cracked the blinds. There was a light on the porch. He could only see someone or something out there. He opened the blinds and the glass sliding door. He took one step onto the concrete, looked like a tussle, could not see an object, and then he described how they were, the vertical on the ground. He yelled out, "What's going on?" Then my point being is he doesn't give another time other than when he heard the gunshot was while he was trying to connect with 911, so that would give us a time. And he said in cross that the entire time he was watching was 8 to 10 seconds. Did that begin when he was looking out the blinds, the crack of the blinds, or did that begin when he took a step out onto the porch and observed that? I don't know. That wasn't testified to. So I'd like to know in this animation where Ms. Lauer's 911 call fits into his testimony.
I can tell you this, that his call connected at 19:17:15, that is in evidence,
So that's 7:17.
7:17 and 15
seconds.
seconds.
Uh-huh.
You know that Ms. Lauer's call started at 19:16:11, and that it is 45 seconds into the call, or at 7:16:56, that the gunshot goes off.
And that's
If you-
different from the timeline that you have up on here in connection with where he was and what he saw.
I disagree, but I understand the court's concern.
Well,
That of course, the way where I believe it lines up is if you use the gunshot as the precise moment of the two calls, not that it was on the call, but if it took Mr. Good somewhere around 15 to 20 seconds to get the call, place it, and wait for it to connect. We don't have that testimony, but we do have Ms. Lauer's testimony, who also testified it took about 20 seconds or so for her to make the phone call and connect. So if
but
you,
he didn't say he said he was waiting for it to connect. And we'll have to look back, I guess, in the record to see if my notes were correct on that or not. And I'm saying these are just my notes.
Sure.
But as I recall him saying he had dialed the 911 and was waiting for it to connect. So that a few seconds here or there, but then again, where's the 8 to 10 seconds that he viewed this?
And where's the 30-second gap between the connection time and the gunshot call and everything else? But the court has hit upon the central problem here, and that is there is no hard and fast ability to say that this is an accurate depiction. That's been the state's perspective all along.
Well, and the case law says it doesn't have to be exact.
But it has to be
And,
accurate.
so I don't necessarily have a problem with other parts of it.
Mhm.
But when you're trying to overlay a 911 call with the animation, I think it has to be closer to exact than not closer.
I understand, and I might be able to fix that by recalling Mr. Good to get a couple of questions answered by him. So I want to make sure that focus, well, I have the right to, so.
No, I'm shaking my head because we're having the hearing now.
I understand.
I'm not going to have this hearing go on for days and days. This
Let me
is the
just-
hearing now, and I guess I should not have, can I please finish? Okay, I guess I should not have commented because then this wouldn't come up and then I could just rule on it after you're finished. I'm not making these comments to cause you to call Mr. Good into this hearing. We have a transcript of what his testimony is, or we could have a transcript as to it. I'll stop talking, let you finish with your evidence, and then I'll make my comments.
I guess my response was going to be to the court that if it is accurate and it seems to be undisputed and in evidence that Mr. Good's phone call was connected at 7:17:15, and that if we have evidence from Ms. Lauer that the decision to make a call to 911 and its connection is about 20 to 25 seconds, and that's in. Then if you were to back it out the time, then I think you are within seconds of when the gunshot was heard on Ms. Lauer's call because of this reason. We know that the gunshot was heard from Ms. Lauer's call at 7.
Let me stop you here. I didn't mean to go into an argument. I'd like you to finish
Okay.
with Mr. Schumacher, and we can get into that.
An argument this
Yes.
time. I think we're at the point where we took some time that, did you utilize Ms. Lauer's call and Mr. Good's testimony as to when, in relation to when he left the view of the scene, when he heard the gunshot?
Yes,
And is that how you then backed out the time, gunshot that Mr. Good heard back in time and sort of went in reverse to when he was viewing the scene?
correct.
And do you recall the time lag that you utilized in order to calibrate that back to the Lauer phone call?
The time lag between,
When he said, going forward in time, when he said he turned away from the scene to when he said he heard the gunshot?
I'm not sure the exact number of seconds.
Can you
That-
let the judge know then what you used in determining when to start the Lauer tape in relation to the video?
Well, in backing it out, his going back inside from the condo is based on consultation with you and from his feedback on the video.
Okay. So does the necessity of being absolutely accurate, is that,
Who's feedback on the video?
Mr. Good,
When did that happen?
consultation in consultation with Mr. Omar.
Can you tell me what date that was?
No,
okay,
Was it after the trial started?
yes.
He was under sequestration as a witness and he was subject to being recalled.
And I was going to have him view the video to document it, and he said there were
It
problems
was
with it.
consultation with changing parts of the video.
Absolutely. As an
Okay, go
expert,
ahead.
as an expert, Your Honor,
Mr. Good's not an expert.
no,
Mr. Good's a witness under witness sequestration.
absolutely. And he was being used to authenticate the animation, since it's his view. He had problems with it, and I attempted to address and fix his problems with it through this expert.
None of which, by the way, has been disclosed to the state till this moment.
Go ahead.
Let's then go forward with the animation.
One, do you need police or medical? Maybe both. I'm not sure. There's just someone screaming outside. Okay, what's the address that they're near? William, is this in the Twin Lake Homes in Sanford? Yes.
We just talked about how this was calibrated, but let's move forward to the initial position. What information did you use to identify this as the initial position of the two?
his comment about, the initial position of.
This
Mr.
position we're
Zimmerman,
looking at now.
That was in consultation with you about some testimony.
Okay. And we also at this point, or did you change this from true animation to still?
Yes, just to eliminate, just to mitigate any random movements, because there was a lot of movements going on. So this was just to show the position, one person's position relative to the other person's position, according to Mr. Good.
And was this then done in order to make it more accurate
Yes,
and to avoid any or other inaccuracies?
yes.
Okay, and is it a male or female?
And then what was this change from the first position to the second position dependent upon?
Also based on consultation with you and from his testimony.
And again, no animation at this point to avoid the concerns you just talked about?
Correct.
It sounds like a male. And you don't know why? I don't know why. I think they're yelling help, but I don't know. It's when someone's like, say crap. Does he look?
And advise the court, if you would, how the determination was made to use the third position.
The third position was from consultation with Dr. DeMaio and also proximity to the prior position, which was just seconds before, and also to the items of evidence around.
Did it also include the final resting place of Mr. Martin?
Eventually,
And is the one we're about to see, that last position, then related to this third position?
Correct, which is marker number 6, which is one of the things that comes into play on the position is also you have a slope there. So it's interaction with the slope.
Is that a slope that's better identified by one of the posters that were viewed by the court earlier?
Yes.
And as we're talking about that, does your computer program have such physical laws like gravity in it so that things will fall in the way they're supposed to fall based upon gravity?
It does, but in this case, those physical properties were provided by the motion capture suit.
Kurt? I can't see him. I don't want to go out there. I don't know what's going on. So listening.
Again, was the decision at this point not to have animation a change from a previous generation?
Correct. It's just to show position.
And this is the position, I'll continue it.
So you think he's yelling help? Yes. All right, what is your...
Before we move, this is the position that was modified based upon your conversation with Dr. DeMaio?
Yes.
And to what extent, again, was it modified?
Leaning over Mr. Zimmerman, just to verify that position with the
And
doctor.
Was the leaning over something you got from Dr. DeMaio based upon his viewing of the clothing and whatnot?
Yes.
And what he discussed with you was his anticipated testimony
Correct.
regarding the clothing and the positioning of the bodies?
Yes.
3.
That was 3 on.
Thank you.
And now it's about to go to the 4th.
Gunshot.
And what you have identified as the after shot position? What information did you utilize to come up with that?
That was our position based on Selma Mora's report of what she saw after the shot.
Okay. Any other information, whether it be from Mr. Zimmerman's testimony, other witnesses' testimony, or eventual identification of the body location, was that used as well?
It was also consistent with Mr. Zimmerman's video testimony.
Okay, I'm done.
I see that there is a
I'm done. I'm
green
done.
circle. I've moved away from it to know the number. I think it's number 6. What is that green circle identified there for?
That would be the location of,
Can we
I
just
believe he said, from Martin on top.
get?
I said with her testimony,
Okay.
then it was my words, it's more likely a left-hand throw. So that was where that part of the animation.
Please, thank you.
Can we just get to our rolling?
That's a trial testimony that was
Can I get this?
to suggest that if otherwise generally accepted.
No. Stop talking.
Or just is assisting that drawing.
Well, I put it this way. It's not exactly just assisting the drawing. This witness couldn't draw a correlation between alleged 911 recordings and the perspective of another
Well, I'm
witness.
not talking about that. You're talking about his use of the computer program and software. I don't agree at this juncture that is necessarily falls within the Daubert test. Because this witness could make those drawings. The issue of relating the 911 call to the animation, it may be a different argument. But what would prevent the defense from having this witness testify to crime scene reconstruction, get off the stand, take an easel board, make a drawing, and at the same time having that witness playing the 911 call and saying to the witness, could you point to where you believe that these events occurred on there?
We would,
That's the difference between whether it is a Daubert or it's just an admissibility issue.
the best answer I can give the court is we wouldn't have to be worried about whether or not the drawing is purported to be accurate. The reason that this animation is being asked to be used as substantive evidence, as well as a demonstrative aid, but substantive evidence, we wouldn't have a witness step down, draw something on an easel, submit it as an
Okay, let
exhibit.
me interrupt you again.
Yes, Your Honor.
If the court were to allow it only as a demonstrative evidence, would you have the same argument?
I would have the same argument from a different point of view. In other words, I think the standard is much higher for submitting it as an actual exhibit, and I think there are more hurdles to jump. I would still be objecting for
Just wasting
some of the same
time.
reasons, although
Would
not
you be
all.
objecting for a Daubert determination if it were demonstrative?
I think probably not, because I think Daubert really applies to evidence that's going to be given to the jury. If I'm assured that it's not going to be given to the jury, I think since it wouldn't be testified to, it would be, if we're talking about using it as a demonstrative exhibit, The
Do
witness
we have to
who would do
listen to
that,
this
Dr.
again?
DeMaio,
I'm not listening
about
to
the
it
position of
again.
the bodies and things,
We didn't listen to it.
has
We
already
don't need to
testified and
listen
done
to
it.
it again.
He didn't need it. He testified quite clearly to his positions on, or his beliefs and opinions about the positions of the bodies and things like that, without even referencing this. He didn't need it. All the other witnesses testified and they didn't need it. So I would say that I wouldn't necessarily mind if counsel wants to use something sort of like this, I guess, as part of a closing argument. If that's the kind of demonstrative aid we're talking about. But I think my objection to it being a demonstrative aid is one of the foundational issues in that regard is it necessary for the witness to help explain their opinion? And the only witnesses who would need it have already testified and didn't need it. What we're now talking about, I guess, if we're talking about, for example, the idea that Mr. Shoemaker would come in here and use this as demonstrative aid to explain his own testimony is only a function of what he's been told by the lawyers and everything else. There's nothing that would be required for the witness testimony to be explained by this. It would simply be a reinterpretation of what has already gone before by that witness. That would be inappropriate from the state's perspective. That's not the use of it. That's not the purpose of a demonstrative exhibit. So that's a long answer to the court's short question, but I think I make that position clear. It depends on sort of demonstrative aid meaning exactly what. If it's used by counsel closing argument, different story and different analysis altogether. If we're talking about a witness, now Mr. Shoemaker coming up, playing this thing and telling everybody what he thinks it means, yes, I do have concerns about that. And I think some of them are Daubert related, but he wouldn't have to, if it's not substantive evidence, meet every one of the Daubert prongs. I'll agree with that.
Go ahead.
Okay. There has been no testimony offered or presented so far as would be the defense's burden about the known or potential rate of error, the maintenance of standards.
I'm done.
Admonishment to the jury.
Trial. Dr. DeMaio testified that the position of Trayvon Martin could have been at different angles. He could have been leaning down or he could have been pulling back. That's my recollection of testimony. So I need you to respond to it.
My understanding of Dr. DeMaio's testimony was in response to them saying he could have been pulling back and George Zimmerman pulling his shirt. Dr. DeMaio said, well, no, that would pull the shirt to one side and then the bullet markings wouldn't match up. So I don't think that Dr. DeMaio gave the alternative suggestion that is now being propounded by
I
the state.
think Mr.
but-
De La Rianda had asked him, given the fact that Mr. Martin says there are no other cases by the defense, I understand both arguments. I need to go back here and read it. You're smiling because I've cut you off so many times. Go ahead.
I promise I'm not going to take you along with this, Judge.
All right,
But I
because we
wanna
have
make-
another issue we have to address.
I know. I just want to make a couple things. Number one, Mr. Shoemaker didn't even mention Dr. Rao. He didn't use her at all. Number two, there's an underlying assumption by the defense here that the nose injury arose from the very first punch, which is depicted there in the animation. But they also claim there were many others landed that could equally have done this, so it didn't have to be the left hand ball. Number two, you can't compare this to timeline, because the timeline
necessary for Mr. Connor to talk about how and where he found the information on the phone.
All I need to know is that he found information on the phone. That doesn't go to whether or not that information is admissible.
Do you see how her
His
tone
testimony
changes
is what
when she's
procedure he
talking
did
to
find
him
something on the phone is
versus
not the
how she's
relevant factor
talking
for
to
what you're
everybody
trying to
else?
do. What
She
you're
does
trying to
not
do is
like
introduce
him.
certain either photos, emails, or text messages. That's what I need to look at. So can I please see what it is that you would be seeking to introduce by way of evidence
She does
through
not
Mr. Connor?
like him.
Yes, I can outline that, yes.
Well, I'd like to
And-
see what it is. You have it there in your hand.
Yes, Judge,
Okay.
I do. I have several pieces of information that were obtained in different ways from Mr. Martin's phone. As the court is aware, this issue is actually ongoing because of the way the discovery has gone in this case. We got a report from the state on June 4th, and we're still trying to process that. But from information that we were provided in discovery sometime in late February, Mr. Connor was able to do some of the extracting. So there are two main issues. One relates to several conversations by Mr. Martin attempting to acquire a firearm. that
These are
occurred.
conversations that are audio conversations, or are they written?
They are text messages
Okay.
that were obtained from his phone, but that's a secondary issue. We'll have a separate exhibit.
Well, no, it's not secondary because that's an authentication issue. If it is his if it's his voice, then that may not be an authentication issue. If it's a text message, it is an authentication issue.
Yes, and I need Mr. Connor to talk about authentication, but to cut to the chase, if you will, on the crux of the matters that relate to the fighting issue. That is the crux of this proffer. It's Mr. Martin's text messages about being in a fight, about the effects of that fight on him, that he got into a fight, that he lost the first round, won the second and third round, bloodied the guy's nose, wasn't done with him yet. Confirmatory text message with another friend, Michael French, confirming that he was in the fight and explaining that he, meaning the opponent, got more hits in the first round because he had me on the ground and I couldn't do anything. A Facebook post from Mr. Martin's half-brother, Demetrius Martin, asking Trayvon Martin, when you're going to teach me how to fight? And the first text message, I was paraphrasing, the one is to a person named Lavondria.
no privacy.
I have the text of that here. I have the,
Got cats.
this was in a
dogs,
hidden file
children.
in Mr. Martin's phone that was password accessible only, in addition to the password required or swipe code to get into the phone. So this was a second level of access that was necessary. I can mark them individually or as a composite. One came from the hidden text messages that Mr. Connor found. One came from a hidden Facebook post that was in an application that was hidden. And then another from the Cellbrite extraction report from Michael French. So I would like to offer Mr. Connor's testimony to explain how he was able to access the phone and what steps were taken that would show that really, realistically, only Trayvon Martin could have created these texts or engaged in these conversations.
Okay, state.
So I'll mark these here for the court to review.
Okay, we'll mark them as composite exhibit NN for the defense for identification. And
It's a three-part. The first one from Lavondria is the more detailed text explaining about the fight that he had just been in and the 3 rounds, et cetera. The other one has to do with the sort of confirmatory text message to this fellow, Michael French, shortly the next day. And then, of course, the separate Facebook posting by Demetrius Martin to Trayvon Martin's Facebook asking when he was going to teach him how to fight. We also can authenticate another way, if the court wants me to go ahead and proffer that as
Please.
well. Oh.
Any of this means, who sent it, what it was about.
Oh my God.
You know, if you look carefully at these, there's no context to them. They're pulled out at certain times, and we don't know any conversation that surrounded them. It's just completely misleading, and therefore it shouldn't be allowed. And I provided the members in the same case to the court
can I have that?
prior to trial. Singh, S-I-N-G-H.
They just shouldn't be allowed because I said so. I said so,
That's
Your
all I have
Honor.
regarding the text regarding
Okay.
plan.
Any further argument from you, Mr. West, regarding the text?
Yes, I have a substantial argument, Your Honor. But I want to proffer Mr. Connor's testimony if the state claims that these are out of context, because we can put them in the context in which they were on the phone.
Well, I'll allow you to proffer as long as I don't go into a long proffer about Mr. Connor's qualifications and his background and all of that. I would like to keep it just to where he found this for the purposes of the proffer. So if you can limit it to that,
Yes,
I will allow the
please.
proffer.
Also, we can ask Mr. Connor to testify. I do think his qualifications are important.
I have him here in a CV. For the purpose of the proffer right now, I don't. You said he got them from a place that was a second level access. If you would like this court to understand what he means by that, I'm happy to hear that proffer. For the purposes of this proffer, I really don't need to go into his qualifications. I have his CV here. It's 00. I can read it.
Yes, ma'am.
So,
The other issue I'd like to
I
point
can
out to
read
the
it.
court before we do the proffer is that Mr. Guy's argument completely misses the point as to why this information is admissible. This isn't reputation evidence under Munoz. This is evidence that directly relates to the physical abilities and capabilities of the individuals at issue. That's a jury instruction that the court will give that directly relates to Mr. Martin's knowledge of fighting, that he had participated in a fight, that he knew, in fact, what it was like to be on the bottom.
well,
and not-
Mr. Connor is not going to testify as to what was intended by this. Is he? Just where he found it and that he found it.
I'm suggesting that Mr. Guy's argument was misleading as to why it's admissible and the significance of it legally. So I don't want the court to think that I'm not responding to the argument because it wasn't the right
I'm
one.
really at the point where I want to hear the limited proffer from Mr. Connor. I'm not at the point to hear the arguments.
All right.
I understand that Mr. Guy gave an argument, but I told you I'd like to hear the limited proffer. So if we could get Mr. Connor in here, we can do that and take it a step at a time.
Right here, just put it through.
Where did he go? He just waddled right out.
There's another exhibit, it's a composite exhibit that I'll ask Mr. Connor to speak with briefly as well, that contain some photographs that were found on the phone.
Ooh.
Offer as defendants, one, generally describe your background and training in the area of computer forensics.
Yes,
In addition to the training specifically,
this. The bin files is more like the physical image of the phone's data. So it contains all the data, all the files, all the free space and everything. So when I have the bin files and I've loaded it into the Cellbrite Physical Analyzer software, I can then examine any file that's from the phone, whether or not Cellbrite was able to parse it or analyze it.
was there something that struck you when you began the process of analyzing the bin file and comparing it with the report that the state attorney's office had provided?
Yes, one of the first things that I did was in the Cellbrite report that I received from the state attorney's office, for each section of the report, it lists how many items are there, how many pictures, how many videos, how many text messages, things like that.
Right,
So I
don't
looked,
care
when
about
I
this
loaded
either.
it into my Cellbrite,
I just want to
handgun on
see if
a
they're going to argue
get deleted
and
with,
they're going to fight.
yes.
What does that mean?
That means that you cannot access the data on the phone unless you input the passcode.
If you don't know the passcode, can you operate the phone?
Perhaps maybe an emergency call, but other than that, no.
Do passcodes typically time out? So that if you access a code, access the phone over a period of time, is there something in the phone that will cause it to become secure so that the passcode has to be re-entered?
Yes, for example, you may have to wait 10 minutes.
Is text messages from whatever source related to firearms and assemble them in the exhibit before you.
Yes, that is what I did.
Let's move to another exhibit. This one's been marked for identification in this proffer as NN. I could approach the witness.
No, no, it was not parsed or analyzed by Cellbrite. So I had to manually identify that it was on the phone and then manually go access the file or the data and look at it. The Cellbrite did not present it for me. I had to manually go find it and look at it and analyze it.
And
Which I
some of that report is reflected in some of the pages of the exhibits before you,
Correct.
as well as some information that may have been extracted through the Cellbrite software itself.
Correct.
And then photographs that you were able to extract from the bin files.
Yes.
That would include the picture of Mr. Martin, the sort of profile picture.
Yes.
And the pictures of the handgun with the hand that we talked about.
Yes.
I don't remember if I asked you this, were the pictures of the handgun with the hand taken by Mr. Martin's phone?
Yes, they were taken by the phone.
Cross?
Mr. Conser, when did you notify defense counsel that you had found some additional information that you didn't believe anybody else had found, or at least anybody else had reported?
I'm sure it was soon after I found it.
So February-ish?
Late February, early March, yes.
And as far as the phone itself, are you aware of whose name that phone was actually in?
I believe it was, yes, I've seen the paperwork. I think it was the mother's maybe. I don't remember whose name was in, but I have seen it.
It was not Trayvon Martin's, correct?
His name was not on the bill, correct, or the account.
And this was actually a phone on a family account, one of several on that account. Am I right?
I believe that's correct.
And can you tell me, you referenced this discussion over a gun. You said it was between two people and either one or both of them was either trying to buy or sell a gun?
No, there were the different conversations I identified. There were 4 or 5 or 6 different ones. In each of them, well, in most of them, Mr. Martin was looking to purchase a gun. In one, there was a discussion about a gun, somebody else's gun. And in the last one, somebody was trying to buy one from Mr. Martin.
Okay. And this was a 22?
There were discussions about several different calibers.
Okay. Obviously, none of which he had on his person the night he was shot and killed by George Zimmerman.
That's what I've heard.
Okay. You know what caliber that was, right?
I don't. I'm sure you guys do.
All right. As far as this, these discussions about fights or fighting, in any of them is, let me just ask it this way. In any of these discussions, can you tell me who was operating the keyboard at the time the messages keypad?
Let me answer it this way. Number one, I was not there when the messages were typed. However, when you view 8,000, 9,000 text messages on a phone, you get a flavor, you get the cadence of the people. And so you get, I think I can get a pretty good idea of whether it's the same person or not.
Is that a long way of saying you would like to think so, but no, you can't tell me for sure?
Again, I was not there when the messages were typed, but do they all appear to be by the same person?
Or when the photos were taken, right?
I was not there, correct.
And in fact, that's the photo, what we've called a profile photo. It looks like you have that on the exhibit there as 3 separate dates, 11/15, 11/30, and 2/10.
No, that's the date. That's the data from the phone. It's on there 3 times.
But it's the same picture,
Yes,
all apparently originally created on 11/15 of 2011.
probably yes.
Okay. So we're not talking about 3 different pictures, 3 different profiles. It's the same picture, just repeated a couple times.
Correct. They have the same hash values, which means it's the same picture.
And that, of course, the profile picture has nothing to do with hands or guns or any of that being visible. It's simply basically just a torso and face shot of Trayvon Martin, right?
Correct.
And it's not posted in connection with either fights or guns, right?
Posted in terms of text messages?
Right.
Correct.
As far as this deletion, deletion can be accomplished by anybody who had access to the phone and knew the app and how it worked, right?
And the codes to get to it, yes.
So as we've discussed, you weren't there to tell me who, if anyone, actually did any of that as it relates to Trayvon Martin's phone.
I was not there when.
When were the deletions accomplished? Were they done all in mass or were they done little by little?
I cannot tell that.
Can't tell that.
No.
So just asking you a hypothetical as an expert.
Mhm.
If a person, parent or sibling or whoever, had discovered stuff in a phone and deleted it, you couldn't tell me whether it was done like that time all at once, or whether, for example, if we assume that the daily user of this phone was Trayvon Martin, he deleted things. You can't tell me which one of those it might have been.
I can give you my opinion.
Okay, based on, I thought you just told me you couldn't tell.
No, there's nothing in the data that tells me when a particular deleted text was deleted.
Okay.
But as you look at it, you can see that certain ones are deleted, certain ones are not deleted, and you can look for patterns. So
But as to when that got done, you can't tell me.
that is correct.
Certainly as to by whom. You can't exactly tell me, although
Well,
I understand you have a suspicion.
I
get
was
that.
I was not there when the texts were deleted.
As far as the material in the phone. Any reason to suspect that George Zimmerman knew anything about any of it on February 26, 2012?
I don't know what George Zimmerman,
Certainly no communications to anybody
I
called
saw
George Zimmerman.
no text to Mr. Zimmerman.
Thank you.
Any redirect?
This idea of this mass deletion of text messages, where the text messages deleted seem to relate to certain subjects.
Certain subjects or certain people. It seems that text messages to and from certain people were deleted. Other ones were not.
Text messages about drugs and drug use that were deleted.
Yes.
Some of the text messages about the guns, trying to get a gun or sell a gun that were deleted.
Yes.
Is there anything
Right, you
that
think
would
they were
indicate to
deleted?
you that
So
someone
maybe
other than
mommy and
Trayvon
daddy
Martin
couldn't read
got
them?
a hold of this phone?
Mommy couldn't read them?
and, deleted a bunch of these messages all at once?
No.
Were there images of pornography on the phone
Yes.
that were not deleted?
Yes.
Oh,
Your Honor, this directly relates to Mr. Mantai's claim that someone else could have deleted these text messages. And I submit that if some family member got a hold of this phone, they wouldn't have gotten rid of the talk about fighting and guns and left all the pornography on it. I think that the court needs to know what else was on the phone that rebuts what Mr. Mantai is suggesting.
Good point.
Scope of proffer, which was only as to these exhibits.
Okay, that, it has nothing to do with the scope of the proffer. I understand your point. Go ahead.
Could you
they would
explain that,
probably want to
please?
get rid of all
Well,
the icky
yes,
things.
there are, the pictures of the gun were hidden also on the phone. And by a separate application that was on there. And what this application did not put them on the
Porn's
SIM
not
card
illegal.
where pictures normally go, but it created a folder, basically in a program file with a French language name. So it looked like it was a French language folder. And it put the pictures in that folder, and it also renamed the extension. The pictures taken with the camera are JPEG pictures and have a JPEG, JPG extension. What this app did was it also changed the extension of the pictures from JPEG to .bin. So in normal computer and digital data use, if, for example, you go to click on a bin file, your app's going to tell you, I don't know what this is, I can't open it. Whereas if you double click on a JPEG, it'll open up as a picture. So this app moved them and hid them, and again, was password protected. And these were pictures that were not deleted off the phone. Whoever was using the phone would have to, again, have the codes to get to those items and know where they were.
Are you saying it's a separate hidden application from the one for the text messages?
Yes,
So there were two hidden applications that required
That you
separate
need.
access.
yes,
That you needed a
And the
password.
text messages were in one of them, and the pictures of the gun, among others, were in another.
yes,
And that, if I hear what you're saying, the casual user of that phone wouldn't see those pictures unless they knew how to access that application.
exactly.
You can have
And the
have a hidden
application
thing.
assigned a different file name, so it would
You can
not
have just a
appear
regular
to be a
hidden-
picture.
Correct. If you were just
You don't have to
browsing
have a
the
special app
content of
for
the
it.
phone,
You can
say
do
you
that
had
in
an
Google
app, so you could browse
Photos.
the folders and files, you would see these as bin files and not
I
as
think I have a
picture
hidden
files.
thing and I don't even know how to get back
thank
to
you.
it. I hid something and I don't know
Thank you.
how
May
to
Mr. Connor
hide
be
it.
excused? May I have the exhibit?
You may.
Thank you. May Mr. Connor be excused?
Yes, Your Honor.
Thank you very
Thank
much, sir. You may be excused.
I think she gets mad.
Okay, the testimony's been proffered. I'll clear argument.
There's additional evidence offered.
As the court is aware, Rachel Gentile has been a witness in this trial, and that she also was deposed. She was deposed over a period of 2 days, a little over a month apart. And of course, the state was present. And at her deposition in April of this year, while she had denied that Mr. Martin had talked with her about fighting, that in the deposition in April, she did then acknowledge that she'd had a conversation with Trayvon Martin where he told her that he was in a fight. And in fact, he told her that he knew how to fight and that he was in a fight that he won. We know from her testimony in trial that she'd only renewed her acquaintance with him after a number of years, in February 1st. So these conversations about fighting, knowing how to fight, having been in a fight that he won, took place within the couple of weeks prior to Mr. Martin traveling to Sanford. So that sort of closes the loop, if you will, on this authentication issue. that I anticipate the state will argue. So we can offer the pages of the transcript, or the court can accept my proffer of the questions.
I'm sorry, I don't understand. Is it your proffer for the purposes of this proffer of Mr. Connor's testimony, or is it another proffer of something you want introduced in the trial in front of the jury?
Your Honor, the larger issue is whether Mr. Connor will be allowed to testify as to the content of these text messages on Mr. Martin's phone. The court has already raised the question of authentication.
I just want what you just told me about the proffer of Ms. Gentel's deposition. Is it for the purposes of this hearing or for the purposes of the trial? Okay, thank you.
I have an excerpt of the deposition that I can just mark as an exhibit that references what I just orally proffered about that deposition.
I'm not saying rejecting, just like to see which I said first to make sure we're in context. Please.
Shut up.
It's concluded.
Is that enough? Thank you, Judge. Okay. So on the argument part of this, we are asking that Mr. Connor be allowed to testify as to the substance of the text messages that he recovered from Trayvon Martin.
Report that has 4 thumbnails. Oh, here they are. They're attached to that. Yes.
Yes, okay. And that has the gun and the hand on the gun?
Yes.
Okay. So I don't want to address that specifically tonight. The hour is late, and I'm not suggesting that Mr. Connor can, at this point, come before the jury and testify about the gun and the hand on the gun and text messages, because I don't think that's been directly related, at least not yet, to the facts of the case. That would go more toward a notion of aggressiveness, maybe even a fact supporting a violent tendency. And
What part of the evidence code are you seeking to have this introduced? This information, all of the information that was proffered by Mr. Connor?
I believe that it most squarely is admissible under, well, no, it's different depending on what parts of the exhibit. The picture of Mr. Martin is simply that he has laid the predicate for a picture of Mr. Martin. That's not related specifically to fighting or guns. It's just a picture of Mr. Martin that was on his phone that shows his physique. That's the relevance of that. The pictures of the gun, the hand on the gun, the discussion of buying a gun and such is not directly related to the fighting issue. The fighting issue, the central core of the presentation, two legal grounds. One is 90.803. That's an exception to the hearsay, prohibition against hearsay that does not require the declarant, that the availability of the declarant is immaterial, and that it relates to an then existing mental, emotional, or physical condition. And in that primary text message with Lavandria, Mr. Martin is asked how he's doing, and he says he's tired and sore. And that's because he had just been in a fight that he had won, a fight.
What part, I understand that, but I'm just trying to find out now, what part of the evidence code are you seeking to have that evidence admitted?
90.803.
She talks really
All of them are
fast.
9803?
The text messages regarding fighting, I'm seeking under 90.803, and also under the legal authority of Chambers versus Mississippi, but that's a separate argument. I'm not addressing the admissibility yet of the firearm pictures, because I don't think that we've connected that up completely with the evidence in the before the jury. So I'd like to concentrate on the evidence of fighting and why that's admissible under several theories. Not as reputation testimony under Munoz and such, but under 90.803 as reflecting a then existing mental, emotional, or physical condition. And that mental or emotional physical condition was at the time that Mr. Martin was in the fight, that he won the fight, and that he explained how he won the fight. He won the fight by, while losing the first round because his opponent was on top of him and rendered him helpless, much like the testimony was that he rendered George Zimmerman helpless in this case.
Okay, can I interrupt you for just a minute?
Mhm.
So you're seeking it under 9803 sub 3?
Uh-huh.
Okay, go ahead.
That's one of the legal grounds. That he talks about having been involved in, obviously, an orchestrated fight that was orchestrated for 3 rounds, that he lost the first round because his opponent was able essentially to take him to the ground and make him helpless by being on top. He also talks about how he won the second and third rounds and therefore actually won the fight. He also talked about how he was able to hit the person in the nose and make their nose bleed, but he wasn't satisfied that there was quite enough blood, so he talks about how he's not done yet with this guy. And of course, he's cautioned by this person that he should quit doing this stuff. that conversation about that particular orchestrated fight is corroborated by the conversation with Michael French that occurs within a few hours while he talks to Mr. French about this event having gone 3 rounds. So we know those are connected in time and in content. Certainly helping toward the authentication that those were the words of Trayvon Martin to 2 people that he communicated with regularly. Mr. Connor talked about how there were conversations with these folks on other subjects and that he extracted just that part of it that related to the fights. There's also a Facebook post includes knowledge, that includes experience, that includes physicians, I guess it is. So we know these things are relevant, frankly, especially the testimony related to firearms corroborates that the shot was fired from the ground up, that the shirt was separated from the skin by a rule of exclusion because the court finds it to be hearsay or any other reason would be.
He's got an orchestrated fight with a referee. He's telling us how many rounds there are. He's telling us that somebody's mounted another person and then they got off the ground. That's not in here. I mean, that's exactly why this type of evidence should not be before a jury. It is rank speculation. He's told a story that is not in these messages on Trayvon Martin's phone. We don't know, again, what type of fight he's talking about. If it's a slap fight, a play fight, a verbal fight, a wrestling fight, we don't know what it is. We don't know if the word fight is code for something else. We don't know anything about if there was a fight between Trayvon Martin and someone else. We don't know who his opponent was. Was he fighting Andre the Giant that he could lose a round to and then beat in a couple other rounds? Or was he fighting a little girl? I mean, that's why this sort of thing should not be admitted. That doesn't even address the authenticity issue. I mean, he keeps saying we've connected all the dots. I submit to you, he hasn't. We don't know who typed these messages. We don't know if they're connected. He said the message with Lavandra and to the other gentleman was hours apart. Actually, they were the next day. The message or the conversation with Rachel Gentile was weeks later, if not months later.
Is weeks. They were only talking for a couple weeks.
Keep talking about the then existing mental state. We don't know when this fight was. There's no indication with any definitiveness as to when these fights took place. So
I'm sorry to interrupt, except as a point of procedure. Mr. Manti did the cross, and now Mr. Guy is doing the argument. Are we allowed to do that here?
Well, Judge, that's why we designed it. It's my issue. I filed a motion in limine. Mr. Connor was Mr. Manti's witness. So that's why we found that that was his witness and my issue.
Okay, go ahead.
This was the issue I argued before the court. Judge, so again, we've got an authenticity issue. We've got whether or not it was then existing mental state. Again, there's no definitiveness as to when these events occurred. But most importantly, we don't know exactly what was meant by these words. Are they code for something else? And again, the danger is exactly what Mr. West has put before the court, that there's an orchestrated fight, that there's a referee, that there's mounting going on, none of which is in here. There's talk about being on the ground. That's it. It is not competent evidence. If there's any probative value, it's outweighed by the prejudicial effect of what a jury might imagine was meant by those text messages that may have been sent by Trayvon Martin. And may have
but you know what? If it was the other way around, I guarantee you'd fight it. And I guarantee you would fight to put that shit in if it was prejudicial
Mr. West said he wanted to address it later
towards
time, so you don't have to address
Zimmerman.
Your Honor, the
So
photograph,
don't play with that.
appears to be Trayvon Martin, but they said they offered it for, I can't remember the term he used, but the best photograph of Trayvon Martin for this jury to consider is the one of him on the medical examiner's table that was taken just shortly after his death. We don't know when this photograph was taken. We don't know if it was something that he took right after he worked out and got all pumped up and maybe took a picture of himself for that reason. We just don't know. But the best photograph are the ones already in evidence that were taken at or about the time of his death. So for that reason, I see no probative value to the photograph, as we already have that in evidence.
Would you not want to show your...
Judge, they relied on Chambers versus Mississippi. Again, I don't think the purpose of that is to eradicate the evidence code and to allow into evidence items that are subject to the type of speculation and misinterpretation that this proposed evidence is. So I would ask the court
But you're allowed to sit there and
grant the state's
use
motion
different tones and
deny this
different
evidence. Thank you.
speculation.
Any further argument?
Only brief response as to the authentication issue specifically. Well, first of all, as to the content of the text messages, they are what they are. I'm not suggesting that we should be allowed to explain them when they're offered to the jury. The jury will see them and give them whatever weight they choose to give them based upon what they believe them to mean. As to the authentication issue, this issue is mired in the mess that discovery on this issue has become. There is a pending motion for sanctions before this court that will be taken up at the end of the trial because Mr. Della Rianda stood before this court and said, we gave the defense everything. We offered the testimony of Wesley White. We offered the testimony of Ben Credos that in fact wasn't true. And we finally got the report from Mr. Brenton at FDLE on June 4th. June 4th, and we still haven't had a chance to go through it because we had the Fry hearing, we've had 2 weeks of jury selection, and what is this, our third week of trial? I can't even keep track of time. There is an ongoing discovery issue, violations. In fact, Mr. Guy stood there silently when Bernie De La Rionda said, we gave him everything. There's no other report. We didn't get any information from anybody different than what we gave them. And we know that's just not true. Mr. O'Mara said to this court, let's relax some of the authentication issues, if nothing else, because we can't get through this issue with the timetable the court has set. There is no authentication issue. In fact, the authentication issue that Mr. Guy raises is illusory. And to the extent this court thinks there is one, it's because of the state's misconduct, not because of anything that we've done.
Even if you were to take everything out of that bin file, it would still be the same issue. It's coming from the same phone.
We did not have the ability,
Well,
we were misled, Judge. We were given
go ahead.
we were given a report at the same time we were given the bin file in late February. The report was misleading. It did not contain the same information that the state had in its possession at that time. We got the report, which was
Mr.
incomplete.
Conner testified that he found 600 additional photos that the state didn't know about. So
That's not true. That's just not
I thought I
true.
heard him say that. I'm
Well,
sorry.
that's what he said, but that's not true that the state didn't know about them. We had testimony before this court from Ben Kritos that he
We're getting
printed
off
2
on a really
reports.
side issue because my point being is if you had 5 years to look at that bin file, it's still coming from the same phone.
We
correct?
only wanted an
It's
extra
still
week.
coming from this same phone, correct? Yes.
The data
So
set
what-
is the data set, yes.
Okay, it's still coming from this phone. The information that you're seeking now to introduce through Mr. Conner, I do have an authentication issue about it. 90.901 is the requirement for authentication or identification. 90.901A, 901.1A, and I'm reading from Earhart. The most common method to authenticate the electronic record or message is by the testimony of a person with knowledge who created the record or message of that printout accurately reflects the contents that the witness created or sent. And it goes on and it brings you to footnote number 3, and it references Griffin versus State, 419 Maryland, 343, 19, A, 3rd, 415, 2011. And State versus Ellick, L-E-C-K, 130 Connecticut Appeals, 632, 23, A, 3rd, 818, 2011 case. An electronic document, example, email, text messaging, and networking sites like Facebook may continue to be authenticated by traditional means such as the direct testimony of the purported author or circumstantial evidence of distinctive characteristics in the document that identify the author. Typically, electronic messages do have self-identifying features. For example, email messages are marked with the sender's email address, text messages are marked with the sender's cell phone number, and Facebook messages are marked with a username and profile picture. Nonetheless, given that such messages could be generated by a third party under the guise of the named sender, opinions from other jurisdictions have not equated evidence of these account usernames or numbers with self-authentication. They cite another case, Commonwealth, are created by or sent by Mr. Martin. I have a concern about that.
Well, we know the phone had a
He's
double
not there
level
to
of security.
authenticate.
We know
Well,
that.
and I know any 7-year-old can learn the passwords and get into that because they do it all the time.
FDLE couldn't do it for a year almost.
Well,
They sent this phone all over the country and they had to write code for it.
But a person
which-
may know that password. Another person may know that password. FDLE didn't know the password.
It's evident under 90.901 that there's evidence sufficient
Valid.
to support a finding that it is what we claim it to be. All of this came off of Trayvon Martin's
Means that
phone.
he's a
There are
17-year-old boy.
thousands of pictures,
Nobody else.
thousands of text messages, no indication that anybody else was using his phone. Mr. Conner looked at all of those text messages. Further, under the authority of is it Manuel?
It's on the same page.
Manuel v. State, is that the one you're talking about? 357 Southwest 3rd, that one?
Yes.
Cited in Earhart's book, I guess, Mr. O'Mara pointed this out to me, to suggest, I don't know what else we could do under these circumstances when the state didn't give us the information timely.
But
We
even if
didn't-
the state gave you that information, is my point. What on these text messages identify that they were created by Mr.
We
Martin?
would have had the time and the opportunity to find the witnesses on the other end, first of all. And we have not had that because of the state withholding valuable exculpatory probative evidence in this case repeatedly, and then misrepresenting to the court what they did. And then finally, when we caught them doing it, we get it on June 4th. Judge, I don't know what else we could have done, frankly. We asked for time. We wanted to depose Steve Brenton. We asked the court to delay the case a few days. I don't know what else we could have conceivably have done under the circumstances to further this authentication issue under the circumstances that the state is solely responsible for. It's simply unfair for Mr. Zimmerman not to be able to put on his defense because of the state's tactics. It was a strategy, obviously, because they had it in January and kept it from us, made us spend 10, 20, 30, 100 hours digging it out, playing games with us, lying to this court, and now it's our fault. It's our fault. To deny Mr. Zimmerman the right to present this information violates both the Florida and the United States Constitution. Thank you.
Does the state want to respond?
Judge, not in substance, but because Mr. West said, I would offer him the opportunity right now to apologize to me for suggesting that I stood by silently with information that I did not have.
I'm not getting into this. Court is in recess. I will give my ruling in the morning. I'll see you at 8 o'clock in the morning. Court is in recess. It is
It's 10 o'clock at night.
9:56. No, court is in recess. Thank you very much. With all
I
due
would
respect, we'll
like
see you
him
at
to
8 in the morning.
apologize to me.
Well,
You sound
at
like
8
a
in the
little
morning, the
bitch.
issue is Mr. Donnelly, who may have violated, or counsel has informed the court that you know that he violated the rule of sequestration. That's the second time today that I've heard that there's been a violation of the rule of sequestration by the witnesses. I don't want to take that up at 9 o'clock and have the jury sit out there and wait like they did today. We will be in recess until 8 in the morning. And so have I.
Not being able to prepare or get my witnesses gathered for tomorrow, and I can't do it tonight.
I'll see you at 8
Judge,
in
I'm
the
not
morning.
physically able to keep up this pace much longer. It's 10 o'clock at night. We started this morning. We've had full days every day. Weekends, depositions at night.
He said, stop, stop, stop. He said, stop, stop, stop. She said, I am done. I am out of here. That's why she doesn't like him. The rule of sequestration. That sounds dirty. All right. That's fun. All of that just for that last little bit. That was the last little bit. That was the only fun part about it. All the rest of it was crap. That was crap. It was boring. I'm sorry you had to sit through that. Because I am sorry I had to sit through that. Okay. Well, that was the end of day 11. We will be on to day 12. And then I'm pretty sure day 11, 12, 13, and then 14 is, I think 13 is part of closing, and then 14 is closing. And then they go to the jury. So don't have much left, and then we're done with this one, and then we're on to the next one. I started a different trial, but I don't know if I want to go like into another trial, especially another trial that's already been done. But I don't really know. This trial was like, it's not 10 years old, it was 10 months old, but it seems interesting. I don't know. I started watching it today. Y'all. Okay, as whatchamacallit would say, y'all, I have questions. So, all right. Let's do the thing. I'll see you on the next one. Peace out.